This Honorable Court of Appeals of Tennessee is now in session.
Good morning to the attorneys and the parties. We welcome you to the Tennessee Court of Appeals. This morning, the proceedings will be as if you were actually in court, except the lawyers will not have to stand when they make their presentation. I assume that all of the time reservations have been made at this point. Is that correct, Mr. Clerk?
Yes, Your Honor.
In that case, if there is no preliminary matters, then Mr. Clerk, will you please call the first case?
Federal National Mortgage Association versus Connie Mundy et al.
And for the appellant, you may present your case, please.
Okay, I just wanted to say that the brief that was filed in November 2020 was not filed by me. It was not my reason I appealed at all. That's the reason my attorney withdrew, so that I could then file what I wanted to appeal, which is the brief I filed May the 14th. And so I just hope that one don't take too much of my time away, because it's not even my issue, really. It's my issues is about, it's a tort case, wrongful foreclosure by Bank of America. And according to the records office, they were the owner and servicer of the loan at the time when they wrongfully foreclosed. There's a dispute whether there's a default.
Ms. Mundy, let me just ask you one question based on what you've just said. In other words, are you saying that the issue that was raised in the original brief that was filed, that's involving standing, that's no longer an issue as far as you're concerned? Is that you on that issue?
That's correct.
All right,
that's correct.
Thank you.
It's really Bank of America is saying there was default, and then I'm claiming there's not, because I have every receipt, documented receipt, as proof. And I asked for a jury trial, and I was granted a jury trial from Judge Thomas back in 2015. And in 2016, Judge Thomas denied Federal National Mortgage Association's motion for summary judgment, because there were still, disputed on the default. And but then after he retired in 2017, ever since then, Federal National Mortgage Association has tried to turn it and make it into an eviction case. And their whole coming about it has been that way. And I've tried to, my attorney I had at the time said that he may add Bank of America to it later. But he kept promising to do so, but he never did. So eventually I asked him to withdraw so that I could file a motion for leave to add Bank of America. And I did that, but I was denied. And so, and I, at no time have I ever asked for a declaratory judgment of any kind. I've always wanted all the facts heard by the jury. And I've been waiting for a long time, 2015, to have the jury. And then 2020, they took it off the schedule and took it away. That's what Fannie Mae's been wanting to do, is take away my jury, been able to hear it, the case, all the facts. And but anyway, see, I was owner, not renter. I've been on the deed since 2012. I paid the taxes in 2012, 13, and 14. And I paid the mortgage all the way up to October 2014 and have proof. And they wrongfully foreclosed in October of 2014. So
what about the original contract? The original contract between the parties?
I see. All right. Well, see, me and my husband, we were engaged to be married, and we picked out the property. And but we weren't married yet. It was 6 months after he purchased it that we got married. So he's the only one on the original note. But when Bank of America foreclosed in October 2014, December of 2014, Bank of America sent him, Harris Mundy, a statement saying that he didn't owe anything on the loan anymore. So, I guess it was satisfied, but I do know that our loan was not a government loan. We paid $20,000 down. It was a non-conformable conservative loan. That's what it was. And so really I was surprised that Fannie Mae even had anything to do with it. But 2 months after the wrongful foreclosure in October 2014 is when Fannie Mae purchased it from Bank of America. And, they tried to leave out Bank of America and just push for the eviction. And I've not been able to show my proof, my receipt. I even tried to show my receipts to Bank of America before they foreclosed, get them to meet with me, but they wouldn't do it.
Man, did you ever have any written agreement with the bank holding the mortgage that allowed you to assume the loan, indicating that they agreed that you could assume the loan? Was there ever anything in writing and filed and recorded indicating that you had the right to assume the loan?
Okay. Bank of America, yes, there is. Bank of America started harassing us. Yes,
is there a document in the record? Is there a document in the record that says that?
Yes.
What document is that, ma'am?
Let me tell you what it does say. It's the one where Paris Mundy signed. Bank of America asked Paris Mundy to sign and send it to him that he's given me the right to handle all matters of the loan, payments, all that stuff. And so that was before he put it in my name. Okay. But we were married. So they got permission to do that. And that was in 2008, but we bought the house in 2002. So Bank of America didn't come on the scene till 2008. But from 2009 on, we've been harassed, and he just his heart couldn't take it no more. I asked him to let me handle it where he don't have to fuss with them no more. And so that's what he did. Bank of America told us to do. And that statement from him is in the record. Also, at the time when he did give all of his rights and everything over to me in 2012, after the divorce, we had it put in the divorce papers, the final divorce papers, that in exchange for me making the payments to Bank of America, principal and interest to Bank of America, and then paying the insurance and taxes separate, that he would give me all of his interest and equity in the property. And
what about, is there anything in the record where Bank of America accepted this arrangement?
They never did make me sign anything, but I mean, they took my payments for 2 years. But now, at some point, I realized that what they were doing, they were letting, they were acting as if I hadn't dropped the PMI, which I had, and by law, and federal law, that it's if you've already paid a certain percentage down, you're enabled then to drop it. If it's not a government loan, you're enabled to drop that and pay it separate, which is, I talked to Bank of America about it. I've got the proof in the record where they wrote a letter to me giving me permission to drop it and pay it separate. And that's in the record. I don't know if y'all have it, but it's in the record. And then, so I was doing that, and then I realized that they're acting as if I'm supposed to be paying the whole thing. And what they were doing was tallying up a fake default, so to speak, a reason to say that they foreclosed. Because I told them one time, I said, ma'am, I'm paying the taxes and insurance. And she said, we know, we are too. So, but there's more land value in this property than the house. There's 5 3/4 acres. And, at one point, and early on when they were just harassing us, I had even suggested that maybe we to get out of the loan, we would cut off some of the acreage and give it to them so that, we could just be done with not and let them have the value of that. And, but, we never did do that. And, let's see here. But there's still, genuine material facts of issue that are disputed, which is whether there was a default. And that means everything to Fannie Mae's case, what happens there, according to Judge Thomas, it was depending on whether their sale would be valid or not, determining if the default was correct or not. And I just want to show my proof to the jury. And I've been denied it all this time, and now they've taken it off the schedule. And I just want my jury trial and show my proof and be done with this,
Okay, thank you very much for your presentation. If you reserve time for rebuttal, then you'll have your rebuttal time.
Okay, thank you.
Okay, at this time, we'll hear from the appellee.
Good morning, Ben Perry on behalf of Federal National Mortgage Association from the Nashville Bar. This case is an unlawful detainer action stemming from the 2014 foreclosure of property located in Hamilton County. Fannie Mae, just to provide some background, we've briefed these issues in our brief and we rely primarily on that, but I'll provide a little bit of background for the court. Fannie Mae was the owner of the loan stemming back many years. Bank of America was its servicer. One of the issues that Ms. Mundy raised below was the fact that Bank of America was not a party to this case. And she referenced Fannie Mae purchasing the property at the sale. As the court is aware, what often happens in these cases is the investor will take title in the event that the foreclosure results in the property reverting back to the owner, which is what happened here. So Fannie Mae obtained title to the property, has owned the property since 2014. Ms. Mundy has been living there without paying rent or property insurance or taxes. In fact, the circuit court ordered her to make payments into court, and she never did so while she continues to maintain use and possession of the property. We would ask that the court summarily affirm the circuit court's judgment, which was based on two independent bases for its judgment in Fannie Mae's favor. The first of which was that Ms. Mundy, who is not a party to the note or the deed of trust, lacks standing to assert any violations of either. She made no attempt to assume the loan or to otherwise assume the loan obligations. In other words, she's trying to take advantage of the benefits of the loan without being responsible for the payments personally. The property she never assumed the loan at any point. I believe when she referenced communications with Bank of America, she was probably referring to a request that Mr. Mundy, her ex-husband, who is the borrower, made to have her communicate with Bank of America. Due to privacy regulations, we can't disclose information to third parties without the borrower's consent. So she's likely referring to a request by Mr. Mundy to have her be able to communicate with Bank of America. The second basis for the circuit court's judgment was that the servicer, Bank of America, complied with all of the requirements of the note and the deed of trust, as well as the Tennessee statutory prerequisites for foreclosure. So in other words, Bank of America complied with all of the notes and deed of trust requirements as far as applying the payments, sending notices, anything that is required in order to effect a valid foreclosure. And on appeal, Ms. Mundy only challenges one of those grounds, which is the standing issue. I understand now that she is attempting in her reply brief to maybe broaden the scope of that, but she doesn't point to any evidence in the record that would negate the circuit court's finding that Bank of America complied with all of the requirements of the deed of trust. So to the extent the court needs to delve into the merits, the payment history is located on pages 334 through 56 of the record. It shows that as of June 2014, she was approximately 23 payments behind, or almost 2 years behind on the loan. And that was shortly after her ex-husband, Mr. Mundy, was discharged from bankruptcy. So at that point, after the discharge, Bank of America initiated foreclosure proceedings,
What year was
Everything was
that?
noticed in accordance with
What year
Tennessee
was
law, and Bank of America
What year
proceeded.
What year
Counsel,
was that? You said that she was 23 months behind? What
Yes, Your Honor.
What year? What year?
In 2014, and that's set
Thank you.
forth in both the payment history and the declaration of the Bank of America representative that we submitted in conjunction with our motion for summary judgment.
Thank you.
And so, unless the court has any questions, I will leave it at that.
I hear none. Thank you very much. It's Monday.
Yes, sir.
You have your rebuttal time.
Okay. Mr. Perry's only been on the case, I think, about a year. It's been going on since 2014. All of the information I've told you is in the record. I don't know how much of the record they sent to you. I asked for a supplement, but I was denied to supplement the record. I was going to make sure you had those pieces. But Bank of America accepted my payments. The whole situation, they've been dealing with me since about 2009 on up. And, you know, and then they sent me that permission to drop the PMI and pay it separate. And I have that in the record as proof. They've just built a false default based on not taking that away, using the taxes and insurance as counting my payment as only partial payment. In other words, because I didn't pay them the taxes and insurance, but I have proof of paying it separate and had sent it to Bank of America to prove.
Were you
I'd
paying
like to
on the
build-
note?
Yes,
Now,
sir.
You paying on the note?
Yes, sir. I paid on it from 2002 to 2014, October, all the way up to when they foreclosed.
Okay, from that period of time, you stopped paying on it, or you still paying on the note?
No, I stopped it when they wrongfully foreclosed because I had to start paying $500 a month to my attorney to defend the case. So I've been wanting this case. I've been wanting a jury to come forward and it be over. I'm not living there free. I've had to defend myself, and it's cost me more hourly fees from the attorney plus the $500 a month. And you know, they were getting their principal and interest, but they wanted to take it because of the land. You know, as far as any payments into Hamilton County, I was only getting like 800 and something Social Security a month. So, and they demanded I pay 1,100 when I wasn't even in court to hear the case to defend myself, because there was no warning, no notice that it was going to be brought up in court that day. So I had no means to do that, but I've been paying dearly for attorney all the way through this case, and I know they say they're the owners, but if you look at the records and you look at them close, they were at one point, but Bank of America, when they foreclosed, were both owner and servicer, it says. And there is an amount. I know what he said about it just defaulting back or whatever, but there is in the record stating that Fannie Mae paid a certain amount for the property in December of 2014. So I don't know. It just sounded like a regular purchase sale to me there by the records. And that's what I'm going by, is the records. But I've not been able to provide any of my proof, any of my receipt proof, nothing since this began. All I've been able to do is tell about it and file what proof I can. But I've been wanting I was granted a jury trial to hear all facts trial. And, you know, I'm being denied due process for how many years? 5 years? This could have been over. You know, it's I just want to be able to have my day in court and present my evidence.
Okay. Is there anything further you want to present in this case?
No, sir, not that I can think of, other than they're wrong. He's wrong about the payments and all. And I've got proof of it too. If I can ever get to a jury, I'd like to be able to do that.
Okay, okay. If there's nothing further, then your case has been submitted to this panel for a resolution. You will receive our opinion within a relatively short period of time. And we want to thank both parties for your presentation to this court. At this time, you may be excused.
Thank you, sir.
Thank you, Your
This
Honor.
court is now in recess until 1:30 p.m.
Thank you.
Amber?